Hi, this is Lee from the Law School Toolbox and the Bar Exam Toolbox. Welcome back to Substantive Spotlight. Today, we're charting the course of a civil lawsuit from cradle to grave, or as we say in legalese, from pleadings to judgment. This is the roadmap episode you've been waiting for, where we'll connect all those procedural dots and see how a case actually unfolds. Think of a lawsuit as a cross-country road trip. There are specific checkpoints you must hit, detours that might appear in various ways the journey can end, sometimes before you reach your intended destination. Today, we'll make sure you know the route like the back of your hand. So let's start with getting the case off the ground. Every lawsuit begins with pleadings, the formal documents that frame the dispute. It all starts with the plaintiff's complaint, which lays out the claims, factual allegations, and requested relief. But here's where students often get tripped up. Since the Supreme Court's decisions in Twombly and Iqbal, a complaint needs more than just bare-bones allegations. It must contain enough factual content to state a claim that's plausible on its face. What does plausible mean? It means the factual allegations must allow the court to reasonably infer the defendant is liable. Merely reciting the elements of a claim without supporting facts won't cut it. Those are just conclusory allegations that courts can disregard. It's like telling a story. You can't just say the defendant was negligent. You need to explain what they did or didn't do that constitutes negligence. After the complaint comes service of process, getting that complaint and summons into the defendant's hands. Under Rule 4, service generally must be made by someone at least 18 years old who's not a party to the case. Following proper service requirements is crucial. Mess this up, and your case could be dismissed before it really begins. It's like failing to properly address an envelope. Your message won't reach its destination. Once served, the defendant has 21 days to respond, or 60 days for federal government defendants. Their typical response is an answer, which admits or denies each allegation and raises any affirmative defenses. Those yes, but arguments, like the statute of limitations or assumption of risk. Alternatively, the defendant might file Rule 12 motions before answering. The most common is a 12b6 motion to dismiss for failure to state a claim, essentially arguing even if everything in the complaint is true, the plaintiff still loses. Other Rule 12 motions challenge personal jurisdiction, venue, or service of process. Think of these as procedural roadblocks the defendant throws up to prevent the case from moving forward. If the case survives these initial challenges, either party might amend their pleadings. Under Rule 15, a party can amend once as a matter of course within 21 days of serving it. After that, they need either the opposing party's consent or the court's permission, which courts should freely give when justice so requires. This amendment flexibility recognizes that parties often learn new information as the case progresses. Also, be aware that certain allegations come with a heightened pleading standard, as you see in FRCP 9b for fraud. Now let's talk about pretrial resolution attempts, how you can end the journey early. Most cases never make it to trial. They're resolved through pretrial motions or settlement. Let's look at the key mechanisms for pretrial resolution. Summary judgment under Rule 56 is the heavyweight champion of pretrial dispositions. A party can move for summary judgment when there's no genuine dispute as to any material fact, and they're entitled to judgment as a matter of law. Unlike a motion to dismiss, summary judgment considers evidence outside the pleadings. Deposition, transcripts, affidavits, documents, anything that would be admissible at trial. It's like saying, let's cut to the chase. We already know this would end at trial, so why bother going? The court views this evidence in the light most favorable to the non-moving party, giving them every reasonable inference. But if no reasonable jury could find for that party based on the undisputed facts, summary judgment is appropriate. It's a powerful tool that prevents cases with clear outcomes from consuming judicial resources. Another resolution mechanism is judgment as a matter of law under Rule 50. During trial, after a party has been fully heard on an issue, the opposing party can move for judgment as a matter of law if there's no legally significant evidentiary basis for a reasonable jury to find for that party. It's like saying, even with their best evidence presented, they still haven't made their case. If the jury has already rendered a verdict, a party can make a renewed motion for judgment as a matter of law, formerly known as a judgment notwithstanding the verdict, or JNOV. The standard is the same. Would a reasonable jury have a legally significant evidentiary basis to find for the party who won the verdict? Sometimes cases end more quietly, through default judgment when the defendant fails to respond, or voluntary dismissal when a plaintiff decides to drop the case. These less dramatic endings still resolve the dispute, just without the full litigation process. So now let's move on to joinder issues. Who's coming along for the ride? Litigation rarely involves just two parties. Joinder rules determine who can or must participate in a lawsuit, making the litigation more efficient by resolving related claims in one proceeding. Permissive joinder under Rule 20 allows multiple plaintiffs to join together, or a plaintiff to sue multiple defendants when their claims arise from the same transaction or occurrence and share a common question of law or fact. It's like carpooling. If people are going to the same place, why not travel together? Required joinder under Rule 19 identifies parties who must be joined if feasible, those whose absence would prevent complete relief, impair the ability to protect their interests, or leave existing parties subject to inconsistent obligations. It's about ensuring everyone with a stake in the outcome has their day in court. Intervention under Rule 24 allows outsiders to join an existing lawsuit, either as a right when they have a significant interest that won't be adequately represented, or permissively when they have a claim or defense sharing a common question with the main action. Think of it as someone saying, hey, I should be part of this conversation too. Impleader or third-party practice under Rule 14 lets a defending party bring in someone who may be liable for all or part of the claim against them. It's like saying, if I'm responsible to the plaintiff, this other person is responsible to me. This commonly occurs in insurance contexts or when multiple parties might share liability. Class actions under Rule 23 allow representative plaintiffs to sue on behalf of many similarly situated individuals. For certification, the class must be numerous enough that individual joinder is impracticable. Members must share common questions of law or fact. The representative's claims must be typical of the class, and the representatives must adequately protect class interests. Class actions are powerful tools for aggregating many small claims that might otherwise go unpursued. Now let's talk about final judgment and beyond, the case's legacy. Once all claims are resolved, the court enters final judgment, which determines the parties' rights and obligations. But the story doesn't necessarily end there. Post-judgment motions provide one last chance to alter the outcome before appeal. A motion for a new trial under Rule 59 argues that the trial was flawed, perhaps due to legal errors, newly discovered evidence, or a verdict against the clear weight of evidence. These motions must be filed within 28 days after entry of judgment. When a case is completely resolved, the doctrines of claim and issue preclusion, also known as res judicata and collateral estoppel, prevent parties from relitigating matters already decided. Claim preclusion bars relitigation of claims that were or could have been raised in a prior action between the same parties that resulted in a final judgment on the merits. Issue preclusion prevents relitigation of specific issues actually litigated and necessarily decided in a prior action. These preclusion doctrines promote finality and judicial economy. Without them, disappointed litigants might keep trying until they win, clogging courts with repetitive suits. It's like saying, you had your chance, we're not replaying this game. Finally, the losing party generally has the right to appeal to a higher court, arguing that the lower court made legal errors. Appeals don't retry facts. They review the legal decisions made during the case. The appellate court may affirm the judgment, reverse it, or remand the case for further proceedings consistent with its opinion. Now let's put it all together and review the case lifecycle. 1. Pleading phase. Plaintiff files the complaint, then there's service of process, then the defendant responds with an answer or Rule 12 motions, and then files amendments if necessary. 2. Discovery phase. Initial disclosures, written discovery, like interrogatories and document requests, depositions, and experts designated and deposed. 3. Pretrial resolution phase. Here you have summary judgment motions, pretrial conferences, and final settlement attempts. And 4. Trial phase. You have jury selection, opening statements, plaintiff's case in chief, judgment as a matter of law motions, defendant's case, closing arguments, jury instructions, and a verdict. And 5, the post-trial phase. You have post-trial motions, entry of judgment, appeal, and enforcement of a judgment. Understanding this progression gives you the big picture of civil procedure, how all those individual rules work together to move a case from filing to resolution. For deeper dives into these topics, check out our Listen and Learn series. Episode 208 and 286, which we will link to in the show notes, cover motions to dismiss and pleading standards. Episode 203 tackles summary judgment, while episode 262 examines judgment as a matter of law and motions for a new trial. For joinder issues, episodes 145 and 153 provide comprehensive coverage. And if you're curious about claim and issue preclusion, episode 148 has you covered. Remember, civil procedure isn't just a collection of isolated rules. It's a coherent system designed to resolve disputes fairly and efficiently. The better you understand how these rules work together, the more effectively you'll navigate the litigation process. Thank you so much for watching Substantive Spotlight on Civil Procedure. If you like this content, please give us a like, leave us a comment, and subscribe so you don't miss any future content.